A contract can be discharged in a number of ways. Once a contract has been successfully agreed upon, there can be several different ways to discharge it or to end it. Performance, mutual agreement, impossibility of performance, and breach of contract. The most common way to discharge a contract is through performance. Simply put, one or more parties fulfill their part of the contract. A contract may also be discharged if the parties involved mutually agree to end it. Various factors may exist for parties to end a contract through mutual agreement. For example, they may agree to terminate the current contract in favor of a newer one with different or additional terms. Frustration of contract occurs when the terms of a contract become impossible to fulfill. Over the years, Canadian courts have excused one or both parties from contracts if it can be proven that certain circumstances prevent them from performing their part of the agreement. For example, a music promoter may have to cancel or reschedule a concert if it has rained out. Failing to perform an obligation owed to another party is a breach of contract. It is the direct opposite of performance. The failure to perform a specific and essential term of a contract is called a breach of condition or a breach of warranty. Any breach allows the other party to cancel or end the contract. If one party has fulfilled most of its terms, this may be looked at as substantial performance, and the party may avoid being found in breach. If a breach of contract occurs, the following remedies are available. Damages awarded to compensate the injured party in the contract. This may take the form of liquidated damages, a sum of money specified in a contract to settle a breach. Specific performance, the court may order a party to fulfill the terms of the contract. Injunctions, the opposite of performance. One party is ordered not to fulfill the terms of the contract. Privity of the contract. In a lawsuit, the plaintiff proves that it had a contractual relationship with the defendants. Rescission. The court may order the contract to be cancelled. In Canada, the sale of goods is a specific area of contract law. An absolute sale occurs when the ownership of a product passes to the buyer. For example, a person buys a car from a dealership and becomes the owner of that car. In order for this sale to be valid, the car buyer must pay for the car, which must be delivered within a specified time, and then the buyer will gain title of the car as well. Sales contracts can have express or implied conditions and warranties. Express conditions are conditions that are essential to the contract and are clearly outlined in it. Express warranties are specific promises that manufacturers and sellers make about the standards of their goods and services. Implied conditions and warranty are promises that sellers make to the buyers that are not explicitly stated, but are presumed by law. For example, the seller has title to the goods and has the right to sell them. Many sellers add disclaimer clauses to contracts to lessen the risk of being sued for breach of implied warranties. These clauses are often in the fine print and are carefully regulated by most provinces and territories.